Thank you, Gene, and thank you, Judge Lamberth, and thank you, Julie. It's good to be here. I have the easiest role here today, and if I play it successfully, you will not hear much, if anything, from me, because we're here to hear from Professors Amar and Judge/Professor McConnell. The ground rules for this, this is intended to be a conversation between these two scholars on our topic of the use of historical sources in understanding and interpreting the Constitution. And as a general matter, we won't have any bells or lights that will go off, but we'll have a discussion. I'll get it started. We'll have a discussion that'll go till about 8:30 or so, and then we'll pause and give the audience opportunities to interact with our scholars this evening. So let's start it that way. The topic is the use of historical sources in understanding the Constitution. So let me throw this out and then let you all run with it. Can either of you think of an example in which the historical record has called into doubt prevailing Supreme Court views of, or historic Supreme Court views of a provision of the Constitution? Is that a fair one to start with? And
well, actually, I think there's unfortunately a list.
Just pick your favorites.
But I think over the last, say, 75 years or so, the most historically misguided, persistent doctrine in the Supreme Court has been the idea of substantive due process. This is the view that a law can be struck down by the court under the Due Process Clause. Well, and then over time, they've had a number of different explanations why. Maybe because it doesn't fall within any of the headings of police power of the states, which is itself not a federal constitutional principle. And more recently, because the courts believe that it's contrary to their own understandings of liberty, and they don't believe that there are powerful enough justifications for the law. I think it's pretty clear historically that the Due Process Clause meant nothing of the sort, and the first cases that even began to intimate such a thing were middle of the 19th century. They were outliers at first, and it hasn't gotten any better than that. When the Supreme Court last justified itself on this in the plurality opinion in Planned Parenthood against Casey, the plurality gave a bit of an intellectual history of the idea of substantive due process, which amounted to the court offered no actual justification for how the text or history could have supported it, but the court said, we've been doing this for almost 100 years, and then proceeded to describe that history, most of which consists of one catastrophe after another, one overruled or repudiated or disastrous decision after another, and that seemed to be sufficient reason to keep on doing it. I'm not persuaded. And within the doctrine of substantive due process, we have just bewildering inconsistencies in what matters and what counts. So, looking just at a modern string of cases, in Griswold against Connecticut, the contraceptive case, the court is all about the importance of marriage to this. So it's the right of married couples to use contraceptives, which is the key, and how important marriage is. And then what is it? Just 2 years later, in Eisenstadt versus Baird, they say, well, it's actually irrational to distinguish between married couples and anyone else. So marriage, which was so important to one decision, becomes actually an irrational factor to consider in the next. And then also in Griswold, the most generally respected of the opinions in Griswold is Justice Harlan's concurring opinion, in which he places enormous emphasis upon actual practice among the many states, and how many states by the time of that decision recognized a right of married couples to use contraceptives and how this had given a kind of reading to the nature of liberty in the United States, and that's a perfectly respectable argument. But then when it comes to Roe versus Wade, where at least 45, if not all 50 states had gone the other way, the practice of the states turns out to be completely irrelevant to their analysis. Or then Casey itself is a paean to stare decisis. It's extremely important for the court to stick to its guns when it makes a decision that's very controversial. It shouldn't be seen to back away just because of political pressure. But then the very next case, Lawrence against Texas, they overrule their prior precedent. Substantive due process has not been, I think it has no historical warrant, and it has not been, it's just been one example of result-oriented, opportunistic decision-making after another. They ought to do away with it.
So I've never been a fan of substantive due process. I'm somewhat critical of it in a book that I have that just came out called America's Unwritten Constitution. I do think there are unenumerated rights. The Ninth Amendment gestures toward that concept, and so does the 14th, but the clause that I tend to focus on exactly is the Privileges and Immunities Clause of the 14th Amendment. 2 or 3 quick thoughts about what Michael has said, almost all of which I think I agree with. So those of you expecting some slugfest may be a little disappointed. Mill Love Fest might be a little closer to what you will end up getting. We'll see. One thing, Michael, in the course of his remarks, talked about, in effect, both the history of the founding and the history of Reconstruction. And it's very important as we celebrate the Constitution to recognize its intergenerational quality. And that's even if you don't think it evolves properly by judges coming up with new brilliant ideas, brilliant to the judges, of course, maybe not to the rest of us. Even if you don't believe that, I'm somewhat skeptical of the brilliance of judges, with the greatest of respect, judges. Even if you don't believe that, I think you should believe that we, the people, have the right to make amendments, and have indeed done so. And Professor McConnell, when he talks about due process, is talking both about the Fifth Amendment at the founding and the 14th Amendment, right after the Civil War. The Constitution we celebrate today is not quite George Washington's Constitution. Great man that he was a slaveholder. He provided for the freeing of his slaves at the end of his life, and that's one of the things I think that makes him especially great, in contradistinction to James Madison, who dies a slaveholder and doesn't free his slaves, or Thomas Jefferson, who talks a good game but does nothing other than drink expensive wine rather than save up so he can actually free his slaves. Great as these founding fathers were, the slavery was part of the original project, and it's not part of ours, and that's because we did make amends. And so I'd want to remind you that we mark not just the 225th anniversary of the Constitution, but the 150th anniversary this week of the Emancipation Proclamation, which occurs right after the Battle of Antietam, which is fought 75 years to the day after Constitution Day, 1787, September 17th, 1862. And Michael gestured in that direction when he used an example that brought in both the founding and the Reconstruction. I myself believe that the Privileges or Immunities Clause of the 14th Amendment is about, for example, applying the Bill of Rights against the states, so-called incorporating the Bill of Rights against the states. There are all sorts of technical questions about how that's properly done, but I do think there has been a lot of evidence over the last 50 years that has been uncovered, beginning with a fellow at University of Chicago named Kroski, who had all sorts of outlandish views on a bunch of things, but did find a lot of interesting stuff about the 14th Amendment, and Hugo Black in in an opinion called Adamson, a dissent built upon that, and that eventually became largely accepted by the Supreme Court, but they called it due process rather than privileges and immunities, and I think that was a mistake of sorts to root this vision of unenumerated rights, maybe even the right of privacy. It sounds a little bit like the word privilege in some ways, and they don't specify all the privileges or immunities. Maybe the amendments 1 through 8, speech, press, free exercise, rights against unreasonable searches and seizures, these are paradigmatic privileges and immunities, but maybe not the only ones. Maybe there are other privileges and immunities too, from state constitutions, American culture, tradition, and all the rest. Maybe the right of privacy might be one of those things of a Griswold sort, of a sort deeply rooted in genuine American tradition and practice. And I commend to you actually an outstanding article that Professor McConnell has written on the importance of tradition in our system. So I pretty much agree, founding and Reconstruction. If you ask me for one other example, I would say the Federalist Papers, which is an historical document, have been hugely influential, maybe no more so than in recent decades. I actually brought some data with me, but I lost it at the train station in my scurrying out, so my apologies. But in a case recently, I think called Prince, there were more than 60 references, all told, in the various opinions by the justices to the Federalist Papers. They disagreed about what the Federalist Papers actually had to say about the issue at hand, which is, could the federal government, in effect, commandeer a state or local sheriff and make a local or state officer enforce a federal law, the Brady Bill requiring gun registration. So they disagree, but in addition to what Michael talked about, I think the Federalist Papers might be a very good example.
Can I follow up on that, or did you want to? I just wanted to ask. Why don't you respond? I've got a follow-up.
Either way, I could. I was going to comment. I do think that Akhil is right to point to privileges and immunities clause of the 14th Amendment as being a much more promising source of authority, especially for incorporating the enumerated rights of the Bill of Rights against the states. There is some direct historical evidence. This is actually one of those debates where there's evidence on both sides, but very substantial evidence that this is so. Calling these things due process rights is really, I think, quite absurd. There's no reason to think, for example, that the freedom of speech or the freedom of religion is due process. These are things that stand on their own bottom. They very well might be privileges or immunities of citizens of the United States, but they are sure not due process. And so I think the court has, by choosing to go this route, it has made a doctrine which actually has a great deal of textual and historical plausibility to it look implausible, and I think law students look at that and they say they must be just making it up. And there's a cost to that, because I think I'm not one who thinks that the Supreme Court just careens from one era to another. I think much of the body of their work has been quite a conscientious interpretation. But it's hard for a teacher of constitutional law to avoid their students getting a rather cynical impression when the arguments that they see in the cases are sometimes so transparently poor.
And you and I both think that a similar thing may be true of voting rights. You and I both believe that it's a bit of a stretch to use the equal protection clause of the 14th Amendment, a clause that talks about persons in emphatic contradistinction to citizens, that is, aliens. That's a pretty weird source of voting rights, a clause that's all about aliens. And if it really were about voting rights, equal protection is paradigmatically about race discrimination. So if it's about race discrimination and voting rights, then why the heck did you need the 15th Amendment? But no one at the time almost no one at the time of the 15th Amendment said this is merely a declaratory provision, the way the 10th Amendment maybe just reaffirms what was already implicit, or maybe some other things just reaffirm. Almost no one thought that of the 15th Amendment. So both Professor McConnell and I have said in the past, and I say most recently in this new book, that the Republican government clause is a more plausible source. So here's this interesting thing. Critics who say, well, the text doesn't matter very much, they say, well, they're making up the substantive due process, and they've ignored the Privileges and Immunities Clause. So the text doesn't mean anything. On the other hand, those might be offsetting mistakes. Maybe actually you could justify a lot of what the court did on one by looking at the other and then therefore using it, the Privileges and Immunities Clause, and restoring it to its proper status. Similarly, they say, well, you've made up all this stuff under equal protection and Republican government you've ignored. But again, maybe these might be interesting offsetting errors. And that's connected to what Professor McConnell just said about how it's possible that the results of the cases are more defensible, but it does make our job as professors a little harder because oftentimes the court stubbornly declines to show how it really is. In the text, it prefers to cite its own cases.
Just very quickly, is, though, one thing to say that privileges and immunities is a shorthand for the rights enumerated in the Bill of Rights, and that those become privileges and immunities of citizens of the United States, were previously applied only to states. That's one thing, and it's quite another to say that something like substantive due process, which is to say that the judges are able to declare laws unconstitutional because they don't agree with them, that's a very different matter.
Yes. So here's why it might matter. If you believe in that is the Privileges or Immunities Clause is the source of this ultimate power to say states can't do certain things, you might think Congress has important authority to define what the privileges and immunities of citizens might be. Section 5 of the 14th Amendment says Congress shall have power to enforce this, and it's somewhat plausible to think, well, the first sentence of the 14th Amendment says everyone born in America is a citizen, and what it means to be a citizen is to have certain rights and freedoms and privileges and immunities that even no state can abridge. And then the 5th section comes along and says Congress shall have power to enforce this. You might think Congress is an important enforcement entity. If it's about privileges and immunities of citizens, it might matter what ordinary citizens think and their privileges or immunities are, and how they act out in their daily lives, how they embody privileges and immunities in a more Burkean way, maybe even unreflectively. But you might think that that might be evidence of privileges and immunities, maybe even the pattern of state laws and state constitutions, which is different than the court looking at its own cases as the fundamental source of these things.
Let me ask a question. Might one explanation for the court's reticence to rely upon the historical record be the fact that they are not historians?
Yes.
And what does that do to the analysis here? If we're talking about resorting to the historical record, what happens when you have generalists who are not historians trying to do that? Now, is that a problem?
I actually think that in the last, 20 years, I don't have a particular number, but the last period of time that the court, across the board, I'm not talking about one wing of the court or another, but across the board, I think has become much more attentive to text and history, and they are able to draw upon scholarly work, and though they do sometimes do the history for themselves, either well or poorly, but I think they have become more attentive to it. A lot of the doctrines which are historically unrooted came from an earlier period when the court seemed not to care as much about it.
Judge, I do think you raise a really difficult question about institutional competence. And Supreme Court justices may, as a practical matter, specialize in constitutional law. De facto, they're a constitutional court to some considerable extent. They, of course, hear antitrust cases and regulatory cases, but their diet is much richer in constitutional law. In other countries, there's a court called a constitutional court that basically uniquely hears constitutional cases, only constitutional cases in some situations, and it's the only court that hears constitutional cases. Constitutional cases are whisked away from courts of general jurisdiction and just heard by this one. So the U.S. Supreme Court justices may be able to develop a bit of an expertise, but every district judge, it's not so easy now. to put in, and this is maybe grounds for certain humility and cautiousness before striking down, especially acts of Congress on the basis of a theory that a judge might have based on history, where the historians are not completely as one on the issue. To put in a plug for ConSource, because that's our job tonight, in the long run, it is possible that as these materials become increasingly available and easy to search, more citizens get involved in the thing. It's crowdsourced to some extent. If you're an optimist, you might think that crowdsourcing, actually many minds will make some progress. Scholars, in turn, over many years, will begin, and it will be a back and forth process, and I'll say something, and Professor McConnell will point out my mistakes, and then I'll adjust, and we'll go back and forth. And, in the Panglossian world, it might very well be that over a long period of time, we do begin to make some progress. Why the Federalist Papers why are they so iconic? Partly it's because from the very beginning, they were very accessible. And even now, you can buy them for $4 with nice indexes, and not to mention now all the word searching that you can do today. And when Storing and other scholars brought anti-federalist material to the surface from the University of Chicago and other places, Philip Curlin and Lerner in the 70s and 80s, there was more scholars started to focus on anti-federalist literature and arguments. And my friend Pauline Mayer, who wrote an outstanding book called Ratification on the year-long ratification process, says she couldn't have done that without the 23, 24-volume project, the documentary history of the ratification of the Constitution, that makes all sorts of things available in each state. Maeva Marcus and her project on the early Supreme Court, or the other projects on the documentary history of the early Congresses, the Thomas website and the Century of Lawmaking that has all sorts of material. So maybe the thought of organizations like ConSource is you make more of this stuff democratically available, and over a very long period of time, we may be able to make some progress.
Interesting that you comment on how inexpensive the paperback copy is of the Federalist, which I do think is important. But since I have a representative of Yale here on the panel with me, I'd like to know, why are the paperback copies of Max Ferran's records of the Federal Convention, why does Yale Press get to charge, $40 for these volumes?
They give me my copies free, so I haven't pushed them too much on this. Maybe that's why they give me my copies free, is they're overcharging the rest of y'all.
Maybe if I can have you focus your attention on an issue that will likely soon before the Supreme Court, and that's the challenge of affirmative action. It seems to me this presents an opportunity for the development of the use of history that Professor McConnell is referring to over the last generation or so, a chance for the Supreme Court to take a look at this vexing issue by paying some attention to the history of the Reconstruction Amendments, which is an area that perhaps hasn't been mined as it should be. But do you all have thoughts about how the court might tackle this issue of affirmative action by getting better acquainted with the history of the Reconstruction Amendments? Or
well, Michael and I actually, just as I was on the train reporting that I was being delayed, we just started chatting a little bit, and he commented on some recent blog postings, actually. There is an argument that the federal government the Congress engaged in a certain kind of affirmative action in the 1860s. One sees this in Eric Schnapper's work and in Jed Rubenfeld's and others. I haven't really written on this topic myself, so I don't have a dog in the fight. there are many ways to distinguish that, to say, well, even if the federal early Congresses right during and after Reconstruction did engage in race-conscious affirmative action, you could say that doesn't count. One obvious way is they were dealing with people who actually had been born slaves, and that's a very different situation than many generations later, even with race classifications of people whose even ancestors may never have experienced slavery. And Barack Obama's didn't, Michelle Obama's did, but they're both reckoned African American. So there are many ways of distinguishing, but one way is, oh, well, the 14th Amendment only applies to states, not the federal government. I myself am somewhat skeptical of that approach, because I do think actually one of the what it means to be a citizen is to be an equal citizen, and that has implications against the federal officialdom as well as states. The 15th Amendment says no race discrimination by either the federal government or the states in voting. Neither the state nor the federal government can have a title of nobility, and to privilege one race over the other on the basis of birth status might be seen as title of nobility. So I myself think that saying, oh, well, that's the federal government, so that doesn't count, is not actually a good basis for distinction, but I can report that that's one of the things that's going on just right now in the blogosphere, are some debates, not just about the words of Reconstruction amendments, but the historical practices accompanying them and what they might mean. Professor McConnell, of course, writes a very famous article, it's controversial, using the history of post 14th Amendment Congresses to shed light on the questions of Brown versus Board of Education. He writes an article in the Virginia Law Review. Professor Klarman, then at Virginia, now at Harvard, has a contrasting take. So there's an example of a big debate about history, not on the affirmative action issue quite so much.
So this will be interesting to watch. I mean, the Texas versus University of Texas versus Fisher, they've granted cert. Obviously a very important case. By no means do I assume that this will necessarily be decided on the basis of anyone's view of history. There are a lot of questions of policy and economics and morality and practicality that they're going to take into consideration, but I do expect history is going to be part of it, and they're going to be scratching their heads. So far, this is in the past forays, it's not been one of the Supreme Court's better sets of moments. I'm often an admirer of Justices Scalia and Thomas, and I like them very much, and please don't overread what I'm about to say, but what they have said about affirmative action is not historically adequate. Justice Thomas, for example, made a simple assertion that against the constitutionality of affirmative action supported by the citation to the Declaration of Independence, all men are created equal. That is maybe the beginning of some thinking about how these questions have been viewed, but that is by no means, that is simply not an adequate matter. Within the academy, there has been some good writing on affirmative action, but I think it has only scratched the surface, and a lot of it has been very tendentious and result-oriented. I haven't myself written about this, although I've toyed with making it a project, because I do think that the history on it is rich and very interesting and very difficult. There is, of course, the question of whether anything that the federal government did is precedent, given the fact that the 14th Amendment applies to states. Akhil has some clever-sounding arguments as to why that maybe isn't right, and of course, going back to Bowling against Sharp, that's been settled constitutional law. But even putting that aside, the Freedmen's Bureau Act is the most important piece of legislation that supporters of affirmative action look to, and of course, it did provide special provisions for freedmen. But I would personally dispute quite strenuously that the category of freedmen is a racial category. It might well be and is true that every member of that category is of one race and that it was not accidentally so, but what they were doing was legislating for the very unique and important situation of people who had lived their lives as slaves and now are free people, and providing them education and providing them some protection in the way in which they entered into contracts and so forth has no real relation to modern day affirmative action, and I don't think it should serve as a precedent. But even that is weakened also by the fact that some of the opponents of the Freedmen's Bureau Act lodged as an argument against it that it was favoritism for the black citizens, and instead of the defenders of the act didn't say, oh, well, but that's okay, there's nothing wrong with that. What they did was that they amended the bill to give various benefits and protections to what they call loyal refugees. These are white citizens in the South who were driven out of their homes during the course of the Confederacy. So by extent, their theory seemed to be that it was necessary to extend the reach of the statute to beyond freedmen in order to counter this particular argument. If anything, that suggests to me that the people at the time of the 14th Amendment were very uncomfortable about anything that might even look like it was a racially based preference or provision. This was not the only example. Other particular things that took place would need to be taken into consideration. I'm sad to say that I cannot identify a sort of one-stop shopping article or book that I think actually canvasses the historical record in a fair and dispassionate way and looks at all of the various arguments on each side. So the justices are going to be facing this case next year, and it's going to be an example where I think academic writing is not going to provide them the kind of help that they're going to need.
So when I, way back when, I think I've written one piece on affirmative action, and there's a paragraph on history, because I basically say I'm not sure. This is a piece with Neil Katyal called Baki's Fate in the UCLA Law Review, and we say it's not really at all clear that history has great resolving power here. So ours was a purely doctrinal analysis of the Supreme Court cases up to that point. And we also say it's also not clear how things that were true of actual slaves are true, have much relevance.
Is that because the history hasn't been done, or because the history is ambiguous?
Well, I thought that I actually do agree with Professor McConnell that I think both. It hasn't been done comprehensively, and to the extent I looked at it, I couldn't make anything that even sounded clever, much less maybe was correct. Now, on clever sounding, just since you did hear about how maybe some of substantive due process is sensibly understood as privileges or immunities. Some of what's equal protection in voting is sensibly recharacterized as Republican government. It might be that the so-called reverse incorporation of the Equal Protection Clause against the federal government, Bowling versus Sharp, is better understood as simply an entailment of the Citizenship Clause, the first sentence of the 14th Amendment that has no state action requirement. And Professor Ryan Williams, in a forthcoming article, he just emailed me the material this morning, apparently, because he read these blog posts, has a new article in the University of Virginia Law Review with hundreds not hundreds, but dozens of quotes and cites. I'll be posting it on the Volokh Conspiracy blog tomorrow. I haven't gone through the whole thing. What I can tell you is, if you think it's clever, do not give me the credit. Because John Marshall Harlan, the great dissenter in Plessy, that's John Marshall freaking Harlan, said it in both Plessy versus Ferguson and in Gibson versus Mississippi for writing for the court. He says the first sentence of the 14th Amendment makes, and the word is citizen, not person, makes everyone an equal citizen, black and white, against both the state and the federal government. That was his view. I think that is pretty clearly the view that you will see in the Civil Rights Act of 1866, that when it comes to civil rights, as distinct from political rights, there is racial equality, and not just in the states, but in the territories. That is not just against state governments, but against the federal government too. So and it's similar to what we were talking about before. Well, maybe the court has used the wrong clause, but has actually gotten to a more sensible result if you're actually trying to show a student where this thing really comes from.
I should apologize for using the word clever. I was really thinking of the titles of nobility argument is the clever argument. The citizenship argument, I think, is a very substantial argument. I'm not yet persuaded by it and haven't read this article, but I'm open to more historical evidence that somebody actually thought about it this way. But the reason I am skeptical as of now, without seeing more, is that I don't actually believe that that particular rights flowed from citizenship. So, for example, even voting didn't.
Well, of course it did, because women are citizens. So, of course not. But civil equality.
Even voting did not follow from citizenship, and the reason why there needed to be more to Section 1 of the 14th Amendment, I think, they didn't just say everyone is citizen, full stop, that does all the work, is because I think they didn't think that it did all the work, that they needed to provide that that there were privileges and immunities. That's why you needed civil rights acts. That's why more things had to be done. And I just think to say that the first sentence does it all. Again, I'm open to the argument, but it strikes me as a bridge too far.
Well, here's just where history comes in, because it turns out that you really do need to understand how words are understood at the time. So here's what because this is something that I have studied. I haven't studied affirmative action and other stuff, but here's how the people talked at the time. What it means, so Dred Scott is a huge case, and it's about several questions about slavery in the territories. And, you got a bunch of justices basically striking down a ban on slavery in the territories, rendering the Republican Party platform unconstitutional. It would be as if today the Supreme Court, rendered the Democratic Party platform from 4 years ago unconstitutional when they promised health care or something. And, of course, the Supreme Court would never do that. On the flip side, in Roe versus Wade, render the Republican Party platform on pro-life things unconstitutional. Of course, the Supreme Court would never do that. Oh, wait, they did with Roe, and they almost did with Obamacare. So Dred Scott is a big case, and everyone is talking about what citizenship entails. And one of the things that Tawney says when he writes Dred Scott is, well, blacks can't be citizens, and among other things, they can't vote. And the dissenter said, what are you talking about? Women are citizens. Women can sue and be sued in diversity jurisdiction. Citizenship is a different concept from voting. So the fact that blacks don't vote doesn't mean they're not citizens. What it means to be a citizen is to have civil rights rather than political rights. And in fact, Article 4 talks about privileges and immunities of citizens in an interstate context. And it says, when I, as a Connecticut person, go to New York, I get they have to treat me as a New Yorker in all sorts of ways. I have to be able to sue and be sued just like New Yorkers in New York State court, and have to be able to own property if I want in New York real estate, and worship in New York churches, and open a business establishment in New York. You have to treat me as a New Yorker, not as an alien, but as a New Yorker for all sorts of purposes, but not for voting, not for jury service, not for militia service, not for office holding, because those political rights are not the privileges or immunities of citizens. So way before the 14th Amendment, there's a very rich, robust American discourse about what citizenship entailed, and it's defined in part by two people. The out-of-stater, Amar, when he's down in Virginia, when he's down in Maryland from Connecticut, or the woman, both of whom are classic paradigmatic citizens, but not voters, not jurymen, not militiamen. This is the vision of citizenship, the dissenting view of Dred Scott that you see in Attorney General Bates's, he writes under Lincoln an opinion saying, Dred Scott is not the law of the land. Blacks are citizens in 1862, basically overruling administratively for executive purposes Dred Scott and defying Taney's courts to say otherwise. And he had a pretty narrow view of citizenship. The framers of the 14th Amendment had a more robust view in which they thought citizenship ipso facto entailed equality on grounds of birth. So if you were born male or female, black or white, you're equal. And it meant to be a citizen meant to have all civil rights, not political rights. Women are citizens, all civil rights. Why do you need to then specify that you can't violate the privileges or immunities? Because the rule of Barron versus Baltimore said if you're going to impose restrictions on states, you have to have language saying no state shall. But you don't need such explicit mother may I, Simon says language vis-a-vis the federal government. All that was implicit in the citizenship grant itself, and they said all that. And that's history, not text. But we don't have ConSource yet, fully, indexing all the Reconstruction materials the way you all are doing this great job at the founding, and we've got to get up to Reconstruction so that you can decide whether I'm just making this stuff up or not.
Okay. At that point, let's turn the time over to the audience, and it looks like we have two microphones here up near the front row, and so we'd invite you to avail yourself of the microphone and direct your question to Professor Amar and Professor McConnell.
One would have thought that George Washington would have played a leading role in addressing and resolving all of these questions that arose as they were attempting to approve the Constitution. What role, if any, did he play?
Well, he is the indispensable man. No George Washington, no Constitution, the way the Constitution looks today. Definitely no Article 2, the way it looks today. The Philadelphia Convention maybe never succeeds because without him as the magnet drawing all the other great men of the continent to this thing. So he does tower literally, figuratively and literally, head and shoulders above all the rest. By acclamation, there are six great men of the Revolution, the first four presidents, Adams, Jefferson, Madison, and Washington, along with Ben Franklin and Alexander Hamilton. Those are the six. Then we have, the next tier, we have the John Jays, and people can debate about Aaron Burr and others. I'm not a big Burr guy, but Washington towers over the others. Unless he is president at the presiding officer at the convention, it doesn't happen. We even call the thing in Article 2 the president, I think partly because they just had got accustomed to calling George Washington Mr. President in Philadelphia. And unless he's going to be the first president, people aren't going to support the thing. They don't have enough confidence in it. And I would say the key role of Washington, there's a whole chapter in the new book on America's Unwritten Constitution, on America's Georgian Constitution, in quotes, sort of following Washington's lead. All sorts of things that are absolutely bedrock in our system, you won't find them in the very laconic words of Article 2. You'll find them in the practices of President George Washington, who liquidates, clarifies, glosses, and textual ambiguity. So in the same way that Christians ask themselves, what would Jesus do? Actually, lawyers, presidents ask themselves, what would George do? What did President George Washington do? And so, for example, under his watch, it's established that presidents can fire cabinet officers at will. Not because that's clear in the text, not because that's clear in the Federalist Papers. In fact, Federalist number 77 by Hamilton suggests you're going to need the Senate to agree to a cabinet firing. But that's not our tradition because of practices that emerged under George Washington. Under George Washington, we get the idea that presidents can send secret envoys and can negotiate treaties on their own, can issue proclamations of international policy, can do all sorts of things that you won't find, can recognize ambassadors or not, can decide whom we're going going to recognize in Libya or Kosovo or Serbia or what have you, because Washington decides whom he's going to recognize in the wake of the French Revolution. So all sorts of things that are absolutely settled are settled not because of the text, not because of the Federalist Papers, the ratification debate, the Philadelphia debates, but because of Washington's precedents, his practices as a president, which get the approval of his fellow citizens.
If I may just follow up for a moment. Surmising what he would have thought about problems is quite different from finding evidence of what he said. Do you find his comments, his take on the various issues that came up during this time in the written word?
Well, he's not a man of many words. He's not a great public speaker. The founders were somewhat skeptical about oratorical demagogues, and he embodies a certain classical Republican virtue. He's not a great speaker. He's not as well educated as others. But look at what he did, and he does lots of things by example, like freeing his slaves and not making a big deal about it, but hoping that people will follow his example. And so here's the things that he did. He signs into law a federal bank bill. And John Marshall and McCulloch relies very prominently on that, saying, if George Washington signed it, that's pretty good for me. And Marshall was Washington's biographer, and he was there at Valley Forge. By the way, George Washington also signed a bill that created a mandate to buy a private bunch of things, to buy ammo and muskets and militia and pouches and knapsacks and all sorts of other things in the Militia Act of 1792. So don't let anyone tell you that Obamacare was the first federal mandate. It wasn't. George Washington signed his name to one. And I think I just made a constitutional argument.
It was just the first mandate justified under the Commerce Clause instead of the Militia Clause. I agree with, what Akhil says is exactly right. But something just to add to it is that Washington was acutely aware that all the decisions that he made would serve as precedent, and he consulted with his cabinet, Hamilton in particular, but also Randolph and Jefferson, and got opinions from them on very important points. He did not himself write. Take the bank as a great example of this, because Jefferson and Randolph both produce, that's the Attorney General and the Secretary of State, both produce opinions that the bank bill is unconstitutional. Hamilton, the Secretary of the Treasury, produces a very lengthy opinion that it is constitutional. Washington goes with Hamilton. He does not actually write an opinion for himself explaining why he's persuaded by Hamilton rather than Randolph and Jefferson. But I think it's fair to say that because he decided that way, that Hamilton's views were in effect the document that we would look to, and on many points, Washington stopped, consulted with the best minds around him, and was very deliberate about what he did. Things like can the president start a war? Does the president need to consult with the Senate in advance of negotiating a treaty? What is the authority of the president with respect to foreign relations with other governments? There were any number of these things, and he made the decisions, and he made them very carefully. So you do look primarily to what he did, and sometimes to the opinions that he was relying upon. But I would add one other thing that he did, which is he wrote letters that establish a number of, these are sort of soft constitutional law principles. But for example, the Jews of America wondered what would their status be in an overwhelmingly Protestant Christian America. And Jews had been in the British Empire had been it sort of fluctuated between benign neglect and overt persecution, but never treated as as equal citizens. And Washington goes out of his way to write a series of letters to the Jewish synagogues around the country, assuring them in beautiful prose that in this new republic they were going to be just as protected as anyone else. And he specifically says, not as a matter of toleration, because toleration is something given from the powerful to someone sort of as a matter of indulgence. They are entitled to the full and free exercise of religion, just like everybody else. So the letters also are part of Washington's contribution.
Just one final thing. You see in McCulloch versus Maryland, Marshall again and again actually cribbing from Hamilton's opinion. If you look at them side by side, the correspondent is very striking, and he explicitly says that this law, after being debated in the Congress and in the executive cabinet, quote, convinced a mind as pure and as intelligent as this country can boast, unquote. That is Washington, and that's an argument emphatically in favor of the bank that George Washington did it, basically siding with Hamilton.
Okay, thank you. Question?
You want me to start?
Yes.
You want to go first? Judge Griffith raised the issue earlier of institutional competence of judges, and I think this is an issue that I think really matters, because constitutional cases are cases first and foremost. They're litigated not just to judges but by lawyers, and so there's an institutional competence issue there of lawyers presenting cases before judges. And I guess my question, maybe just, I'd like to hear a little bit more about, obviously our focus here, appropriately so, on Constitution Day is on the history of the Constitution per se, but I know Professor McConnell started with criticism of the substantive due process clause on the grounds that all that now we can rely on in substantive due process is past cases. There's, of course, some sense in which that's history, too. But I wonder, when the one thing we do know judges can do well and lawyers can do well is cite, distinguish cases. It's what they do. It's what, I'm a law professor at the University of Wisconsin, and I can tell you it's what we teach. Probably maybe we should teach more history. Maybe we should force all students to take history classes in their first year. But the reality is that is something that lawyers do very well. They've been taught to do it, and judges do very well. And so I'm wondering if I could hear the two of you talk a little bit about the relationship between, precedent, stare decisis on the one hand, and history, sort of original history, on the other.
Well, one thought is, as lawyers tee up cases, it may very well be that just as they have to hire economists in antitrust cases, or experts in foreign law in conflict cases. Maeve is nodding her head because she knows where I'm going. They're going to have to hire her and other distinguished legal historians to maybe help them out and therefore help the court understand certain things. We are going to see historians, but maybe unfortunately too adversarial, too forensic, too one-sided in the affirmative action case. There were various historical briefs in Heller and City of Chicago versus McDonald, these cases about the Second Amendment, partly because there wasn't a lot of Supreme Court case law. And so, faute de mieux, these were somewhat clean slates, and so the historians were able to come in and maybe play a bigger role. I'm sure Michael has thoughts.
I'm not sure that judges are worse historians than they are anything else. I don't.
Thanks a lot.
I don't see the law and economics movement worrying greatly about the fact that judges aren't trained economists. They still think cases a certain range of cases should be decided according to economic logic, and that's what the job of lawyers is to simplify that and present it in a way that judges are going to understand. The same thing, I think, is true of history. And James Wilson said law is a historical science, and I think that is so. I do think that the way constitutional law is taught at most law schools doesn't prepare future generations of lawyers as well as it should for being able to deal with the historical dimension of constitutional argument. But that's our fault. That's not the judge's fault. But let me say something in defense of them, since this may sound very critical. I think having generalist judges is one of the great strengths of our rule of law system. I think that they are not experts, but that means that they are going to be open to arguments of a variety of sorts. They're going to be much more commonsensical. Experts become bureaucratic, and I think one of the great things about the American judiciary is how unbureaucratic it is. The people who make the decisions actually hear the arguments. They actually read the sources. There's no levels of, lots of functionaries in between, and because they'll have an antitrust case in the morning and a constitutional case in the afternoon and a common law case sandwiched in between, and then a very statutory interpretation case before, they have to master a wide variety of modes of thought, and I think we get better judging that way than we do in systems, say, that have a constitutional court and that's all that they do. I can't prove that. It's just an instinct watching them that yes, we sacrifice expertise, but I think we get some humanity and broader perspective in return for that. And so, no, they don't know their history as well as I wish that they did, but it's better than the alternative systems.
Thank you. Question here?
I have a question about the unwritten Constitution, and I haven't read Professor Amar's book yet, so maybe it's all there, and I'm just asking prematurely to that. I've just read things that other people have written about it. But I understand that, Akhil, you can correct me if I'm wrong, that you argue that certain extra-constitutional documents or kind of consensuses that develop can inform and in effect amend the Constitution. I'm not sure if this is a sort of modernization of a constitutional moment theory, but I'm just trying to understand how the Constitution evolves extra-textually like this. And let's say, for example, currently there are great majorities of Americans that don't think that the government can mandate you to buy things. The Supreme Court by 5-4 agrees with that, but let's say that changes at some point. All of a sudden, without having to amend the Constitution, would that power exist?
So Ilya is referring in part to a book review that the Wall Street Journal ran last Saturday by Professor Randy Barnett of this city, of my new book. And I think my friend Randy got some things basically wrong in that review, and I offered a corrective in a place called the Volokh Conspiracy, which is especially read by right-of-center law types. Here's what I say. Suppose at time T1, a court recognizes a right before it really has embedded itself generally in the culture and the practice. Okay, in Griswold, they didn't do that. Really, 49 states had always allowed married couples to engage in conjugal relations using contraception, and only Connecticut, of all the states in all the entirety of American history, ever did otherwise. So Griswold didn't jump the gun, but suppose the court did jump the gun. Roe versus Wade surely jumped the gun if the test is tradition, because Roe versus Wade strikes down the laws of 49 of the 50 states. Only New York is probably Roe compliant, and maybe D.C., but I think only New York, okay. But suppose that a court recognizes an unenumerated right before its time, but then that right comes to be very widely embraced by the citizenry insinuates itself in the culture, celebrated even and practiced even by those who were initially critical of the court's decision. My claim is at that point, it might very well be that the Ninth Amendment and the Privileges and Immunities Clause that they just talked about actually made this right, which was the court made this court decision, which was wrong at T1, actually right later on, precisely because now it really is a right of the people, because the people have embraced it. Now it really is a privilege or immunity of citizens because people actually have accepted. This is not the way to think about textual rights. If the right's in the Constitution, judges enforce it, whether it's popular or unpopular. So, in effect, this was, I thought Randy would like this idea. This is a libertarian idea. Extra rights, yes. Not fewer rights, but more rights, unenumerated. So I actually thought there was an asymmetry, and I was very explicit about this, and he completely, with all due respect, to his, book review, I do know what I wrote, and that's what I said, and I thought he would have liked that. I thought you libertarian types would like that idea. I didn't really talk so much about that.
I find that argument a little puzzling because once everybody has embraced this idea, like the right to use contraceptives, you don't need constitutional law to protect it anymore. Constitutional law is about, when, or at least within judicial review, it's about when the laws are contrary, and if everybody agrees with it, then we don't need to call it a constitutional right. It's just going to be protected by ordinary democratic legislation.
Everybody may overstate it. Griswold, I basically think it's everybody, but I live in what was on that issue in Nutty State. It's about trimming off the outliers, and that actually was a law passed in 1870. And so you're right. It's you might. So I'm trying to pander, of course, to all sides here. So the libertarians should like the asymmetry, and the traditionalists and judicial restraint folks should like the idea that this is actually not wildly activist. This is about trimming off the occasional outlier, a la Griswold versus Connecticut. Can't we all get along?
Thank you. I think this will be the last question.
Please regard this question as sort of illustrative. For decades after the 1787 Constitution, the Privileges and Immunity Clause was pretty well ignored well into the 20th century. Why should we care whether George Washington wrote a letter to someone saying, boy, oh boy, this Privileges and Immunity Clause, that's going to be a big deal? Why should that matter?
History is a different, maybe, from text in this regard. Something that's in the text of the Constitution, by that very fact, is iconic. And ours is a Constitution that reveres and worships, ours is a culture, that reveres and worships the Constitution, even though most people don't read it. And this is a disgrace that they don't, because it's short enough to be, I almost pulled out some family photographs here, which you don't want to see those, but it's short enough for ordinary people to read and engage this. That's why it was short, because 225 years ago this month, a project was put before the American people. We, the people, ordinary farmers, could decide whether they were for this or against it. It was short enough to be basically understood, which is why it can't itemize everything, like a right to a bank or every right, for example. There might be unenumerated rights because you can't list them all. So it's short so the ordinary people can read it, and ours is a culture that reveres the Constitution, and you all are out on a Friday night, and you could be doing other stuff because this is a constitutional culture we have, and that's why Senator Byrd got that law passed about how every educational institution is supposed to have some constitutional content. And here's what that means. That means any clause, this might not be true of a letter by Washington, but any clause in the Constitution itself, it may lay dormant for a very long time, but has the capacity to be revived. The 10th Amendment, 35 years ago, law professors scoffed at it. It was a truism. You've seen a huge revival of that. The Second Amendment, you definitely saw. When Chief Justice Warren Burger, who was no, ultra-liberal guy, said something like a quote, the idea that the Second Amendment creates an individual right to have a gun is one of the biggest frauds, I repeat frauds, this is all a direct quote, ever perpetrated. That's what a lot of people thought. There was a bunch of scholarship. That's what I actually originally thought before I did some of the research. I came to change my mind about some of these things, partly because of the 14th Amendment experience. The Freedmen's Bureau bill and other things from the 1860s, to me, were very powerful. But the Second Amendment was utterly obscure. It's now at the center. What was true of the 10th, what was true of the Privileges or Immunities Clause, could become in the future true of the Republican Government Clause or the Privileges or Immunities Clause or other things. Washington letters, I don't know as much about, but if it's in the text, it's iconic and it has this capacity to revive. I don't know if Michael agrees with that.
Well, I think I do. Actually, talking about letters, very important decision of the Supreme Court this year, the Hosanna Tabor Evangelical Lutheran Church and School versus EEOC unanimously held that church bodies have an unfettered right to choose their ministers for themselves, even in the face of civil rights anti-employment discrimination laws that would seem to interfere with that. And one of the key things that the court mentioned was a letter from James Madison to the having to do with the selection of the first bishop of New Orleans after the Louisiana Purchase. This was a letter which has received almost no attention until then. Comes from has to go back to a 1905 source to cite it because it was not in the common parlance, but it was so much on point that he made it a centerpiece of the opinion. But I do totally agree with Akhil that the issue of text really is the key. So privileges and immunities, it doesn't matter how many centuries they go by ignoring it, it's still in the Constitution. And one of the ways I think in which the Constitution does us a huge service is that so ordinary constitutional law goes on with cases and stare decisis, and the Supreme Court will do this, and then the next case will be based upon its own case. And this is the way ordinary things go ordinarily. But sometimes you sit back and you say, where we have ended up bears little resemblance to the fundamental charter that we supposedly are interpreting. And the fact that we have a text gives us an opportunity to be critical of current practice. It gives us, it's like that, the sand and the oyster that can produce a pearl, because otherwise we would just go on complacently with the Plessy versus Ferguson's and so forth of Supreme Court doctrine. The Constitution, every so often, it's a wonderful thing that people pick it up and they read it and they say, what we're now doing is very hard to justify in this way, and that gives us the opportunity to change. It gives us a basis for being self-critical. It gives us it can cut through the complacency of the present. It's an antidote to path-dependent repetition of mistakes, and as a real instrument for reform and reflection.
Yeah, so my analogy to that, maybe not the oyster, but maybe again a seafaring one, a compass, and that you can regularly have recourse to see if you've drifted off course. And so I don't believe, Ilya, that merely because certain things in the Constitution become unpopular or unfashionable, that generally speaking constitutes an amendment of the Constitution. No, mine was a particular point about unenumerated rights that can become popular even if they weren't when they were initially announced, and that would count. And any reason that it's popular doesn't really matter, but if it's now popular, it should be enforced. And it won't won't need to be enforced very much, Michael says, because if it's genuinely popular, only weirdo legislatures maybe are going to be violating it. What does this have to do with history? Coming back finally to ConSource, here's one idea. It's, I think, very prominently associated with colleagues of mine like Bruce Ackerman and Jed Rubenfeld. The text memorializes experiences that we, the people, had earlier. Rights actually were violated. Needed powers weren't granted. And so we, the people, actually, to deal with the problem of inadequate power in the Articles of Federation, gave broad power to the federal government. And it's in the text. We, the people, because certain rights were violated or were at risk of being violated, actually on the ground put stuff in saying we will never do this again. These are commitments. These memorialize actual history. Alan Dershowitz has a phrase that rights come from wrongs. They don't come, and they come actually from historical experience. And precisely when they're successful, and we don't have the abuse consistently, ordinary people might sort of forget what it was that really was to be avoided. Generations arise that know not Joseph. But if we look back at the text and we understand it in its historical context and the mischief that gave rise to it, the reason why we, the people, earlier really did make the great effort of putting it in the text, because very few things actually make it into the text, this can be a way of us as a people recollecting, remembering what it was that, and why it was that we did these certain things. And that's history meeting text.
Well, we thank you, Professor Amar, and thank you, Professor McConnell, and thank you, audience, and thank you, ConSource, for putting this evening together. Thank you very much.